Cuyahoga County Operations and Intergovernmental Relations Committee meeting for Tuesday, March 1st, Super Tuesday, 2016 is called to order. And the clerk will please call the roll.
Calling the roll, Mr. Miller.
Here.
Ms. Simon. Ms. Simon is absent. Mr. Brady.
Here.
Mr. Germana. Here. Mr. Greenspan.
Here.
We have a quorum.
Thank you very much. Has anyone signed in for public comment related to the agenda?
No, Mr. Chair, no one has signed in.
Thank you very much. The minutes from the February 16th, 2016 meeting are in your packet. Do we have a motion relative to those minutes? It's been moved and seconded to approve the minutes as presented. Any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed say no. The minutes are approved. And under matters referred to the committee, we have the second hearing on proposed ordinance 2016-0002, the update to the ethics ordinance. And Ms. Christina.
Ordinance 2016-0002, amending titles 4 and 5 of the Cuyahoga County Code to clarify the ethical rights, responsibilities, and prohibitions applicable to elected officials, employees, board members, contractors, and lobbyists of Cuyahoga County.
Thank you very much, and this is the second hearing on this piece of legislation following the initial hearing. We received input, we considered it, we had further discussion, and a substitute version has been brought forward, and I would ask the sponsor, Councilman Greenspan, if you would like to make a motion to accept the substitute as the version of this legislation before the committee.
So moved.
And I will second that motion. And I will call upon Mike King to give us a summary of how what's in the substitute version differs from what was introduced.
Thank you, Mr. Chair. Michael King, council staff. I'm going to go through some of the more substantive highlights that are in the proposed substitute. These came from discussions both with the county executive as well as other stakeholders, some suggestions that were received, and including this committee at the last committee meeting. Some of these changes, and you'll see them as redlined in your packet, are really technical clarifications, so I may not touch on every single item that's redlined here, but I will, if you have any questions about any particular change, please feel free to stop me as we go through. Beginning on page 3, the definition of the term gift was amended, and basically what this does is it excludes from the definition of gift items that are considered to be de minimis, and this is consistent with what the Ohio Ethics Commission, how they define a thing of value and what they consider to be a substantial item for the purposes of running their analysis. And really the thought behind this is de minimis items really are de minimis in the sense of, and if you look at like the Black's Law Dictionary definition of de minimis, it's something of trifling consequence in a matter that's so small it's unworthy of consideration. So that was one substantive change in there. And really the thought behind that was, if we're going to be considering gifts for the purposes of the $75 threshold, something that, having contractors or even, employees or officials, if they get a cup of coffee or something like that, tracking all of that in terms of an aggregate gift would be impractical. So that is, again, consistent with what the state prescribes, and was a reasonable change of scope. The next change is on page 4. It's the definition of lobbyist. There are a couple changes here. One is actually about the definition of a lobbyist in terms of how much time someone would need to spend lobbying to be required to register and pay the $100 registration fee as a lobbyist. As it is currently submitted before this committee, it would say you have to spend at least 5% of your time lobbying council or 25% of your time lobbying the county executive. This was changed to a flat 10%. And it wouldn't be limited to lobbying council or the executive. It would be activities lobbying any government entity. And the rationale behind that was there are plenty of people out there who are lobbyists professionally who may lobby the state or federal government, who may come to council or the executive on a one-issue basis, but should be registered as lobbyists. So in many ways, this is expanding the definition of lobbyist, but it's creating a more uniform standard to say 10% of your time. The other change in here, which was actually recommended by the chair, is that we're limiting the definition of lobbyist to not include those who solely provide testimony at public comment, or who performs any actions without compensation. And again, that comports with another change later in this related to First Amendment rights of those who want to advocate for particular policies. The next change is in section 403.01 A, and this has to do with who conducts the training for employees and elected officials and board members. It was written such that the Department of Human Resources be the entity to conduct this training. The executive asked that specific reference be removed. Not that there wouldn't be training for these individuals, the training would still be required, but to give flexibility depending on the circumstances for either the Inspector General or the Department of Human Resources, or potentially even another entity that might be appropriate. Obviously, the Inspector General would have to approve the training materials. The next change, substantive, is in section 403.03, and this was really a consolidation of paragraphs B and C. They applied similar but not quite identical standards, and it seemed to be a little bit confusing. So basically, section B was deleted, and the core elements of that section were inserted into paragraph C, which is now being renamed as section B. So it's basically it has to do with elected employees or elected officials, employees, and board members either coercing or requiring or requesting their subordinates to perform work unreasonably outside the scope of their employment, and without offering just compensation with regard to the request. So that's the subject matter there. The next substantive change is on page 6. It's under paragraph 403.04, paragraph C. And this was a limitation on what actions were required recusal for when conflicts of interest arose. It's currently written that any matter involving the exercise of discretion would require recusal automatically where a conflict existed. This is a very broad standard, so this was actually amended to more closely mirror the prohibitions in the revised code, particularly in revised code section 292142, which deals with the awarding of public contracts, to say that any decision that authorizes an approval of a public contract or the investment of public funds would require that type of recusal. So that is a somewhat limiting provision, but it is again similar to the state standard.
On that item, what is the reason for not using the broader standard of any exercise of discretion?
I think, I don't have an example for you, but I think the concept of saying that any matter where you could exercise discretion is very, very general. So you may be, an employee may be performing their job in some form or another, and they may have to make discretionary decisions as part of that function. But if they don't ultimately make so say an employee in Public Works has financial interest in a construction company, and they as part of their job as an employee of Public Works have to manage certain types of contracts, certain types of projects. Well, they may not directly be involved in awarding a contract or determining who scoring contracts or this or that, but they may have areas where they can make judgment calls, but again, aren't directly related to award of contracts, but that could implicate or indirectly confer some type of financial benefit to one of their family members, something like that. I think a matter involving exercise of discretion was just a vague standard to apply. So that was really the intent behind the change.
So suppose that that the person in Public Works Department had responsibility to inspect the contract for contract compliance, and a family member of theirs had an interest in the contracting company, and suppose that they had the option to either hold them to the standard that was in the contract as to the quality of materials or performance of work, or else to let it go. And under this standard, under the new standard, would that require recusal or no?
That's a good question. I don't believe it will require recusal under this standard, though I'm trying to think. It could implicate other issues from a fraud standpoint. I mean, I don't know if that would necessarily constitute fraud, but I don't believe, for the purposes of this section, I don't believe it would be encompassed. It would not require recusal in this instance.
Okay, please continue.
Mr. Chairman,
Yes.
just on this point, 403, Part C. I'm looking at this as an elected official because that's how it starts, and that's what I am. I'm reading down it, and I'm looking. Finally, I come down here and it says, okay, himself, herself, a relative, or any private organization which he or she has an interest. Private organization, how's that defined? Does that mean for profit? Does that include not for profit? And if it does include a not for profit, how does it amount to? How does it amount to financial or material benefit?
Right. So to the council president through the chair, the code doesn't define what a private organization is. I think the purpose behind that is that it's not a public organization. It is not a governmental entity or political subdivision. The code does define what an interest is, and I can just read you the definition. It means a direct financial or material benefit, but does not include any benefit arising from the provision or receipt of any services generally available to a lawful class of residents or taxpayers of the county. And an individual is deemed to have an interest in any private organization when he or she, his or her spouse, or a member of his or her household is an owner, partner, member, director, officer, or employee, or owns or controls more than 5% of an organization's outstanding stock. Provided, however, that an individual appointed to serve on a private organization who solely acts on behalf of the county. So, for instance, the county has individuals who serve on the Gateway Board. That is a private organization, but they are representing the county in their capacity as representing that board. Someone serving on that board representing the county would not be considered to have an interest in that organization.
Well, I think I'm sure I understand the general intent of it, and I don't have any problem with that. What I want to, satisfy myself about is that we don't somehow inadvertently tie our own hands to be able to function, because a lot of what goes on around this city, we have to be able to deal with lots of entities around this city. How do you determine whether you have any material benefit? I would assume that strictly means what it sounds like, and that's actual financial benefit, something that's actually quantifiable, and that would be in your financial interest. But it can't be, I mean, I don't want, it has to be tight enough. Do you know where I'm trying to get at?
I believe so, and I'm happy to work with you if you'd like to work on a more
Okay.
refined definition
All right.
of material benefit or
All right,
interest.
it
or
may be
however.
fine the way it is.
Yeah.
Thank you, Mr. Chairman.
Okay. Please continue.
So the next, let me make sure I'm on the right section here. The next substantive change is on page 9, and it's under the financial disclosure section. And it's basically how it's currently drafted is that elected officials have to, it says they have to file with the Ohio Ethics Commission in accordance with their disclosure statement in accordance with the deadlines established by the Ohio Ethics Commission. It was brought to our attention that not all elected officials have to file directly with the Ohio Ethics Commission. Sometimes there are other filing requirements. So really this was just changed to say that the appropriate filing agency by the deadline prescribed by the Ethics Commission. So it's really all elected officials would have to file, but it would just go to whichever the appropriate filing agency is.
So, Mr. Chair, if I could just shed some light on that, this came as a result currently of my own situation, in that I don't file an ethics financial disclosure statement with the Ohio Ethics Commission. I file with JLAC, and so JLAC then files with the OEC on my behalf, but I don't file. So the way this was written, I would be in violation because I'm not filing with the Ohio Ethics Commission, even though I've done everything prescribed by law that I'm required to do. That's just a practical example.
So the next change is on page 11, and it has to do with future employment. And again, this is the revolving door provision that prohibits county employees and officials from coming and representing a private employer on behalf of that private employer before the county on a matter in which they personally participated. There was language in paragraph C limiting that prohibition to exclude individuals who represent an organization on an uncompensated basis. And that was actually due to a constitutional challenge at the state level to their revolving door provision. The courts have determined that if you're representing somebody pro bono, then you're not prohibited from advocating. It was a First Amendment concern. The next change is on page 12. And this was at the request of the chair at the last committee, that the language prohibiting employees or elected officials from making political contributions up to 12 months after terminating their employment or service with the county was limited to the point in time when their service terminated. So it no longer, that prohibition no longer extends beyond the termination of service with the county. Let me see. The next significant or change of note is on page 15. This has to do, remember, with the registration, training, and disclosure requirements for lobbyists. And under paragraph D, it specifically exempts certain types of organizations from having to register and undergo training as a lobbyist. And there was a request by the county executive that this provision be added to exclude not-for-profit corporations solely seeking to provide a free service or financial or in-kind support for a county program or initiative. So if a local foundation or other entity wanted to finance a program that the county was operating or running and solely wanted to finance that, they weren't looking to leverage county dollars or secure any other type of contract or anything like that, that they would not have to register as a lobbyist, and in that they were providing that support. The next change, and this was noted at the last committee, is on page 18, and this has to do with the whistleblower rights and responsibilities. As was mentioned at the last committee meeting, there was some clarification as to how whistleblowers would be required to file reports of retaliation. So if somebody filed a claim alleging an ethical violation and received some type of retaliation for that, be it an adverse employment action or some other type of retaliation, the structure that was in place was that they could appeal that adverse employment action or other retaliation with the Personnel Review Commission, and that seemed to be the most logical place for them to go. It was brought to our attention that under state law, there is a provision in Chapter 124 which specifically says that if there is a whistleblower appeal under state or federal law, that the employee's sole and exclusive remedy, notwithstanding any other provision of law, is to file an appeal with the State Personnel Board of Review, also known as PBR. So basically what we've done here, and there may be further clarifications, we're still working with the law department to refine this language a little bit, but is to say that if you are filing a whistleblower appeal under state or federal law, that you have to go to SPBR, and that's, there's really nothing we as a county entity can do about that. That is what the state has established as the sole and exclusive remedy. And we believe that the intent behind that was to say, if you're a local government or even if you're at a state level agency, you have a neutral third party in SPBR to hear those types of whistleblower claims. It's hard to sort of guess the legislative intent there. But it also provides that if there is an alleged whistleblower complaint under county law, so not state or federal law, which SPBR doesn't recognize and wouldn't hear those appeals, that the employees would then go to the Personnel Review Commission. So it's a little convoluted, but it bifurcates the appeal paths for employees depending on what type of whistleblower complaint they're filing. And unfortunately, there's no real way to address that while retaining full, whistleblower protections. The next change is on page 20. And this was in response to a request by the chair at the last committee meeting to clarify who determines, again, remember, for gifts over $75, there's a presumption of influence that the employee can rebut, or elected official or board member can rebut if they accept such a gift, but it was unclear as to who was to determine what constitutes a reasonable gift and what constitutes an unreasonable gift. This clarifies that is the role of the Inspector General, and it guarantees employees or elected officials or individuals under investigation for accepting gifts that they have an opportunity to provide the Inspector General evidence rebutting a presumption of influence before the Inspector General renders a final decision. This is actually similar to a standard we have for debarment of contractors. Contractors who are under investigation get a notice that they might be debarred. They have an opportunity to come to the Inspector General and say, here's countervailing evidence suggesting that debarment may not be appropriate. The next change is on page 21, and we're getting close to the end here. At the top, in paragraph M, there was some discussion about who was the appropriate entity to prepare the ethics policy manual. And again, this is meant to be guidance for employees and officials and board members. And as it's currently drafted, it would have the Department of Law prepare this policy manual in consultation with the Inspector General. There was just some discussion that at the end of the day, as the enforcing agency, the Inspector General should probably be the entity to promulgate that guidance, but instead with the consultation of the Department of Law. So this later on is deleted as one of the enforcement mechanisms for the Department of Law. So this was added as a responsibility of the Inspector General. The next section, 407.02, still on page 21. This is the role of the Personnel Review Commission. As we mentioned, the PRC hears whistleblower appeals for claims of retaliation. But the existing code has a number of responsibilities that the PRC doesn't actually perform on a day-to-day basis. Things like posting whistleblower policies in county departments, providing copies of Ohio and county laws relating to ethics, conducting ethics training program classes for county employees, and writing, and sending letters of notification, admonition, and censure regarding violations. These are responsibilities that have traditionally been performed either by the Department of Human Resources or the Inspector General. And so in this section, some of these responsibilities have been relocated. They're stricken here, but they've been relocated either primarily in the Department of Human Resources. And we've shared this with the Executive Director of the Personnel Review Commission. She's bringing it to the commissioners tomorrow at their bi-monthly meeting. So they're going to let us know if they have any issue with this, but we had a preliminary conversation, and Councilman Greenspan and myself, and she did not seem to be overly concerned, with the understanding that most of these functions are already being performed by the Department of Human Resources. And with that, that is the totality of the substantive changes to the ethics ordinance in this proposed substitute.
Okay, thank you very much for the presentation. Any further comments about accepting the substitute, Councilman Greenspan?
The only other comment I want to make on these, and I appreciate Mr. King and Todd for working on bringing these issues to light, is that from the last meeting to this meeting, the county executive has agreed to sign on as a co-sponsor.
Great. So the question is on the motion to accept the substitute as the working version of this legislation. Before voting on that motion, I would like to offer an amendment to the motion, which would be to not include the amendment to section 403.04C, which is the change from the language exercise of discretion, moving it to authorization or appropriation of a public contract or investment of public funds. And I'm not saying that we might not ultimately use that language, but I think the proposed language may be too narrow, and I want to do further study on it and work with staff. And so for now, I would like to accept the substitute with the existing language pending further study on the possible revision on that one particular section. So
Mr. Chair, which section are you talking about again?
I'm
40304C.
We're talking about 40304C on the second last paragraph on page 6.
Well, let me ask you this. Procedurally, are we able to make an amendment on a document that's yet to be voted on?
Absolutely.
Okay.
We're simply the motion would be if my amendment is accepted, we would simply be accepting the substitute without that one change included. This is something we've done before. There's no reason why we can't. It's just a question of whether the committee agrees.
So if I can, so the new language, the language then would revert back to its original language as is currently before us, and in that we would be adding back in the words exercise of discretion and remove authorization through the word funds. Is that correct?
That's correct. We would, in that one paragraph, we would not substitute, but just use the existing language in the ordinance as introduced.
I mean, as a matter of moving this legislation along, I don't have an issue with that, but we just need to make sure we circle back on this issue. I just looked to Mr. King or to Mr. Ellsworth. So if you're making the motion, I'll second the motion to amend to its original state, but I don't want us to lose sight of this proposed amendment.
As the chair, I will also take responsibility to make sure that that's further worked on. Yes.
I don't understand what the objection is. What is the difference?
The objection is that given the example that we were talking about before, where an employee, for example, might have the task to inspect the work of a contractor that was working for the county, and the employee might have a personal relationship with that company. I think there could be circumstances where what the employee would be doing would not directly relate to either approving a contract or investing public money, but it still would be where they were exercising their discretion in making decisions on behalf of the county where there could be a conflict of interest. So I think that that the new language might put too narrow of a scope around the recusal requirement, that it might exclude some situations where recusal would actually be appropriate, and I just at least want to suspend judgment on this question and use the broader language for now and give it further study between now and the next meeting.
I understand, and I'm just wondering if that should be something separate. I mean, this is two different things, I believe, because this is not voting or approving it, but I can understand where if an employee knows a company or something and they're supposed to be inspecting it, or in matters of if it was in human resources or whatever, if there's that conflict, it's different than approving a contract. So I actually think that's like a separate conflict of interest.
Perhaps having it as a separate section might be a solution that we might consider. But what I'm suggesting is that because of the uncertainty over this provision, that for now we should just retain the language that was in the language as introduced and give it further study. And we might leave the existing language as is. We might go to the language that was proposed as the alternative, or we might go to a third possibility. Any further discussion on this point? Hearing none, the question is on the amendment, which would exclude the one change in paragraph C to the substitute before the substitute is accepted. All those in favor of the amendment say aye. Aye. Any opposed say no. The ayes have it. The amendment is incorporated into the motion. Any further discussion on accepting the substitute? Hearing none. All those in favor say aye. Aye. Any opposed say no. The ayes have it, and the substitute is accepted with the one paragraph retaining the current language. The next thing that I would like to do is to call to people's attention the expanded comparison document. It's this document that has three columns, and I would point out for those in the audience that we made a few additional copies in case anyone in the public wants one. And the reason why we had this document prepared was that it was brought to our attention that because the ethics ordinance update was not a line-by-line revision, but instead there was a fair amount of rearranging that was done, that it was difficult to know exactly what all the changes are that are being proposed. And so the aim here was to provide a comprehensive presentation of all the changes that are in this proposed update, so that everybody could know exactly what it does and what it doesn't do. And so I would like to call on Mike to go over the comparison document, but not to cover everything in detail, but focus on those areas where the compare document provides a finer level of detail than we received in the original document that described the ordinance.
Thank you, Mr. Chair. So just for the structure of this document, as the chair mentioned, it's 3 columns. The left-handmost column is the existing code of ethics that's currently in effect. The middle column is what's reflected in the legislation before you today. And then as adopted in the proposed substitute, with obviously the one caveat to the change to section 403.04C that was just made. And then in the right-hand column is a little bit of analysis and some of the summary of changes. And this column is very similar to the document you received at the last committee meeting. So to just go through it at sort of a high level, the first section that it covers is the definitions. Again, we're looking to narrow the definition section to define only those terms really essential for the purpose of the code, and it provides a more refined definition in certain areas. In paragraphs D and E on the right-hand column, you can see a list of the terms that are no longer defined in the new code and a list of newly defined terms in the new code. So if you have any questions about definitions, and as you'll see going through 8 pages of this document, that we've tried to reduce the number of defined terms. Sometimes definitions are useful, sometimes they can be overly complicated in terms of statutory interpretation. So we tried to simplify it there. The next section begins on page 9. This has to do with the compliance of state and federal law. And this is one area where we didn't rewrite verbatim what's in the existing code, only because there are voluminous Ohio Revised Code sections that were basically supplanted or transplanted from the revised code as it existed in 2011. Some of these sections have actually been updated, not in any material way that would be concerning, but if they were updated at some point in the future, that we might have a potential conflict there. So these sections, and they're all listed here, 1 through 15, all still apply to county employees and elected officials. There's no question about that. It's just that we simply refer to these sections in the updated code. It says, that all of these sections still apply to county employees as they may be amended, including without limitations chapters 102, 124 as incorporated, chapter 303, 2921, and 3517. And actually that's an additional section of the revised code that isn't in the current ordinance that was added as reference here. And that section is actually regulates campaign finance. And that's just to make sure that elected officials, employees understand what restrictions are imposed upon them under state law when it comes to making or soliciting contributions for certain types of elections. So that, and we can go into greater detail on that as if we get to political contributions, if there are any questions there. But that was another section that seemed to be important to note again. The next section begins on page 10. This is the training of county officials and employees. This is, again, the updated code explicitly permits electronic acknowledgement of training and clarifies which agencies are responsible for conducting the training. Typically, the Inspector General or the Department of Human Resources would perform such training. The next section is use and misuse of county resources. This was really a simplification in the sense of we no longer are including the procurement card policies in the ethics code. Those are really more procurement policies, but the use of procurement cards are still explicitly considered, procurement card usage is still explicitly considered a county resource. So if somebody improperly uses a procurement card, they are still subject to all ethical violations, but we thought it was unnecessary to include specific regulations as to how procurement cards are used. That is a procurement card policy that is administered by our our Office of Procurement and Diversity. The next section begins on page 15, which is the use and misuse of official position. A general provision has been added prohibiting the use of official position to secure certain material or financial benefits, mirroring ethical requirements in the Ohio Revised Code. And a new provision prohibits county officials and employees from selling goods or services to the county except through the competitive bidding process. And that's also a revised code requirement, but we wanted to make sure it was also applicable under our code. One thing that's actually not in the current code that is in the revised code that we did want to carry through as specifically applicable as well is that the awarding of contracts in violation of revised code section 292142, which again is the awarding of public contract, improper awarding of public contracts, that section of the revised code says that if you improperly award a public contract, that contract is void and unenforceable. And we wanted to make sure that was mirrored in our code as well. And then finally, the ordering of goods and services for county purposes without prior official authorization is no longer per se an ethical violation, but remains an internal control matter. And any unauthorized ordering of goods or services for personal or non-county purposes continues to be an ethical violation. So if you're ordering something for your personal use or for your private business, that is still clearly an ethical violation. But if you, for instance, fail to check a box in some type of purchase requirement, procurement requirement, and it was an oversight, or maybe there was some internal control that was oversaw, but it was still in the interest of the county to make that purchase or authorize that purchase, then it isn't, again, it doesn't rise to the level of an ethical violation. The next section, conflicts of interest, page 18. Obviously, this was just discussed, but the requirements are significantly reworded, but are substantially similar. The language used is a little bit different. In the existing code, it says that public officials and employees have to recuse themselves where a conflict of interest exists. But unfortunately, if you go back to the definition section, the definition of a conflict of interest is a little ambiguous, somewhat vague. So that was part of the reason we wanted to rewrite the language as to what constituted an interest and what matters specifically required a recusal. So again, we can work to more clearly define which matters in particular require recusal and which do not. But that is one of the changes stylistically to help clarify and make it a slightly easier standard for people to follow. The updated code also prohibits individuals from obtaining a financial interest in exchange for services rendered. This isn't something specifically prohibited by the current code. If you have an interest, you're prohibited, you have to recuse yourself, but this is more of a quid pro quo type of thing where if you've rendered services in exchange for obtaining an interest, that is also prohibited explicitly. And then we've refined how employees or elected officials could request an opinion as to whether a conflict of interest exists. So if you are unsure whether a conflict of interest exists, you can either go to the Inspector General or the Department of Law, depending on the circumstances, whichever is more appropriate in that context. So it's providing a few more avenues to help get an opinion. And then there are a few explicit exceptions to the recusal requirements established with respect to particular matters of general applicability. And these are the adoption of the county's biennial budget, matters that don't involve the exercise of discretion, or matters involving the exercise of discretion that directly affects all elected officials or employees, all residents or taxpayers of the county or the general public. The concept here being that if you're voting on a tax increase, or voting on a tax decrease, actually, you may have a direct financial interest in seeing a tax decrease, your taxes will go down. But if it's affecting everybody in the county equally, that is a matter of public policy. It's a determination. You wouldn't have a conflict of interest there. So those are the changes for conflicts of interest. The next section deals with nepotism. Again, this was reworded, but applies a similar standard with the one caveat that the term relative has been redefined to not just include full family members, but as well as more extended family. But it reduces the prohibition, so it doesn't prohibit employees from working in an office with a relative. It prohibits a direct supervisory relationship or employment decisions. So hiring, firing, promotion, relatives can't make those types of decisions for other employees they're related to. And then it also explicitly incorporates the prohibition again in ORC 292142 on using one's influence to secure a public contract for a family member. The next section relates to gifts, and we went through pretty comprehensively the changes in the last committee meeting, but it changes the existing $75 hard cap on acceptance of gifts from contractors as lobbyists to a presumption of influence standard. So it allows employees and elected officials to say, I received a gift over $75, but maybe there are some types of extenuating circumstances that make this reasonable and customary and would not rise to the level of an ethical violation. And as discussed a little bit earlier, it would be up to the Inspector General to hear that evidence from those employees or elected officials before rendering a final decision and make that final decision as to whether or not a gift was improper. The next section has to deal with financial disclosure requirements, and this was an issue that we wanted to clean up a little bit because it wasn't necessarily clear for certain levels of employees who was exactly required to file financial disclosure statements with the Inspector General. In particular, the section, it's at the bottom of page 26 here under subsection 6. It says directors, deputy directors, administrators, or similarly titled employees that report directly to the individuals identified in subsections 1, 2, and 3, which are the county officers and directors and the Inspector General. There are instances where deputy directors county agencies are structured in very different ways. There are a number of deputies that aren't called deputies. Some are called administrators, some are called assistants. There are certain reporting structures that aren't easily definable in these terms. And there are instances, for instance, where perhaps everybody in a department, if it's a small department or agency, that everybody reports directly to the director. Well, in that instance, is everybody in the department required to file a financial disclosure statement? It was an unclear standard, and it was difficult to apply. And I know that both, I can't speak for the current Inspector General, but the past Inspector General, had a number of questions as to who was required to file. So what we've tried to do here is apply a standard that's a little clearer. Obviously, it's a little hard to anticipate all positions that could exist in county government, but we basically say if you are a director or officer of the county or chief of staff of an elected official, that you have to file a financial disclosure statement. But we also say that if you are a chief or deputy to which a director reports, that you will also have to file a financial disclosure statement. So basically we're saying that if you have the elected official at the top and you have directors here, anybody in between that level, that cabinet level position, also has to file. But anybody below the director level doesn't have to file. And really that's more of an accountability issue to say, these are the people making the major decisions on behalf of the county. The directors, mostly in this instance, the executive office, but it also applies to the chief of staff of the council and the prosecutor. They have to file that financial disclosure, and then at the very top you have the executive or whoever the elected officials are. They obviously have to file per state law. So we're trying to make that cutoff at the director level and get rid of some of the lower level positions where it wasn't exactly clear and didn't apply equally across the county. The one caveat to that is that we still require health and human services administrators, because of the scope of their responsibility over such large departments within the county, to file as well. So they are effectively they have similar responsibilities to other types of departmental directors. So directors of Department of Children and Family Services, Senior and Adult, Child Support Enforcement Agency, et cetera, would also still have to file.
Mr. Chair, if I could add to this, this is more or less broad. It's doing two things, and it's going to sound contradictory to one another as I say it. It's intended to broaden the definition, but also confine it at the same time. And by that, what I mean is the charter is very specific as to the intent that directors are to report to the executive. However, given the flexibility of the evolving government, there are opportunities for individuals, and it's happened since day one, that sit in between the director and the executive who are in influential positions of policy. And so the intent here is to more adequately delineate the line above and below to which the disclosure is required, but also provide flexibility to the administration to be able to structure their organization in such a way as to not be where this is not inhibitive of their ability to perform their jobs. Does that summarize it?
Correct.
Thank you.
So the next section is on page 28. It relates to secondary employment. There are a couple changes here. One is that the we create specific exceptions. The current standard is that employees have to report all secondary employment and private business activity. And again, there was a difficult standard to enforce as to what constitutes a private business activity. There are certain things that clearly, if you operate your own business, if you operate as a private contractor in a professional capacity, that is a private business. There are other activities that may less clearly be considered private businesses. So what we tried to do was specify what types of income would you receive that wouldn't really constitute private business activity. So in section A1 of the updated code, we specifically exempt, and this is linked to the IRS's requirements for gross income reporting. It excludes interest income, dividends, corporate contributions, alimony income, or income from life insurance, endowments, income in respect of a decedent, retirement plans, pensions and annuities, and Social Security, PERS, or equivalent retirement benefits. So those are types of income that wouldn't inherently cause a type of conflict of interest that one might be concerned about in a secondary employment setting. So that types of income, employees and elected officials clearly don't have to report. The other change, again, this was mentioned at the last committee, was that employees don't have to resign immediately if there's a conflict of interest that could come up as part of their job duties. So to the example we had before, if an individual working in public works had an interest in a construction company, they may have a conflict of interest, but that conflict of interest may not rise to the level that they have to pick or choose one or the other. Say they work for, have a private business on the side where they work for a construction company in their off hours. They wouldn't have to necessarily pick and choose. They would have to recuse themselves from matters where it would be appropriate, where that conflict of interest would have issues, and we'll obviously more clearly define that. But the inspector, they still have to report that secondary employment, and the inspector general would be responsible for determining whether the conflict of interest rises to the level that they simply cannot perform both jobs at the same time. They have to choose either to terminate their outside employment or their employment with the county. And how we define that is to say whether the conflict would preclude an employee from performing a substantial portion of his or her job duties. So again, it's not a clear-cut standard, but it is one that I think provides a little more guidance to the inspector general and to employees. The other minor change here is that it requires employees to request approval. If you're an employee who accepts a position of outside employment, you no longer have to receive prior approval from the inspector general. You can request approval after you have to request within 30 days of accepting that employment, and then the inspector general has 14 days to make a determination about whether a conflict would preclude you from holding that outside position. The next section is on future employment. Again, these are the revolving door provisions. This, as it currently stands, the existing code is really just the incorporated portion or the copied and pasted portion of the revised code in 102.03a. Again, we're no longer copying and pasting that section of the revised code. We're instituting a similar standard, but with the caveat, as noted earlier, to make sure that those representing persons or an organization on an uncompensated basis are not prohibited from doing so. And again, this is to address constitutional concerns. The next section is on page 33. This relates to discrimination. The prohibition on discrimination still applies. In fact, it applies broader than it does in the current code. It applies not only to elected officials and employees and board members, but also to lobbyists and contractors. There are also a couple additional protected classes, and some of these are classes that are specifically mentioned in the charter, including discrimination on the basis of national origin, sex, and genetic information. And these are things that aren't in the existing code. It omits the section relating directly to sexual harassment and on the basis of political affiliation. And the thought behind, well, I'll address sexual harassment first, and this was mentioned at the last committee. Sexual harassment is obviously is sex discrimination, and that's something that has been determined by courts for decades. There's a whole doctrine around both quid pro quo and hostile work environment, and our HR, both federal law, state law, and our HR policies and procedures manual prohibit it. I believe it is encompassed within the prohibition on the discrimination on the basis of sex, in the updated code, but the specific reference to sexual harassment is I think more appropriately put into the HR policies and procedures manual, and it is located in there as well. The omission of discrimination on the basis of political affiliation was due to a concern that there are certain boards and commissions out there that require political identification as part of it. So for instance, the Board of Revision, the Personnel Review Commission, and Metro Health both have restrictions as to board membership based on explicitly on the basis of political affiliation. So in those instances, we wanted to make sure there wasn't a conflict here. So that was the reason behind omitting that term. The next section is on political contributions. It's on page 34. It's the very next page. Again, this section was updated. The prohibition on making of political contributions has been narrowed to contributions on behalf of employees to their elected officials. It was determined that prohibiting board members, particularly those who serve in an uncompensated capacity, from making political contributions violated their First Amendment rights to participate in the political process. And I know there was some discussion at the last committee about even whether we could extend the scope beyond those of classified employees. As stated earlier, this does mirror what's in the campaign finance regulations at the state level that apply to state employees and their elected officials, and we feel comfortable that this could be upheld. And again, it explicitly incorporates the updated code, the revised code's prohibition on the classified civil service employees from engaging in partisan political activity, which is in Chapter 124 of the revised code. The next section, dealing with whistleblowers. Again, we talked about this at some length earlier, relating to the state versus the local whistleblower rights and responsibilities. I'll leave it at that unless there are any other questions about what avenues. And again, there may be some additional clarifications from the law department as to the process and how appeals would work. The next section is on page 39, dealing with contractor and lobbyist registration. Other than some reorganization, these standards are very similar to what currently exists. The prohibitions on gifts applicable to elected officials, employees, and board members apply in reverse to contractors and lobbyists. They are prohibited from giving rather than receiving. One change is that it sets a set registration threshold for contractors at $10,000 annually. And if you look at the old code, the existing code versus the updated code, you'll see that there are actually a couple thresholds under the existing code. One's set at 5,000, one's at 15,000, and it has to do with who has to register and who has to pay the registration fee and undergo the training. In conversations with some of the stakeholders, it was determined that it's simpler to simply have a single dollar cutoff. So we sort of split the difference and said, rather than a $5,000 threshold and a $15,000 threshold, let's do a $10,000 threshold. If you do more than $10,000 worth of business with the county, you have to register, you have to do the training, you have to pay the registration fee. And again, contractors are responsible for keeping track of how much they do business with the county. If they fail to do that and end up having contracts in excess of $10,000 and fail to register at that point, then they could be subject to an investigation and possible debarment for that. And those are things that I know it was raised at the last committee that, shouldn't we be proactively monitoring that? That I believe would be administratively burdensome for our procurement department, but it is something that the Inspector General and procurement can both easily verify if there was some allegation that somebody was failing to register and had exceeded that $10,000 threshold. So, yes.
On that, I would also point out that a whole lot of the contracts we do are for $10,000 or more annually, and any time we hit that amount in a single contract, well, then it's going to be automatic. So
That's correct.
That's going to reduce the amount of this reliance on the contractors for monitoring.
Very true. Additionally, there are some types of entities that are explicitly exempted from training requirements and registration fees. as either lobbyists or contractors. For instance, not-for-profit, as we mentioned, not-for-profit corporations solely seeking to provide free service or financial or in-kind support for a county program or initiative are exempt from lobbying. Public utilities don't have to register as contractors. They are akin. We currently don't require governmental entities to register as contractors because we tend to know who those are. It was determined that public utilities are similar in nature and wouldn't have to register as county contractors. And then the registration and training requirements for lobbyists no longer apply to bona fide members of the media who are maybe, are advocating for a public policy in an editorial of some nature, but wouldn't, there are First Amendment considerations there. Governmental entities or their agents on matters of governmental interest, and attorneys or other representatives who are representing a client with the county. So if someone is engaged in a claim or settlement with the county, they don't have to register with a lobbyist simply because they're advocating for a particular outcome or policy related to that matter.
Mr. Chair? I see we have contractors and lobbyists concerning registration. Is it possible that a governmental agency can subscribe to a ethical ethics requirement so that the contractor or lobbyist has got to follow our ethical, whatever we subscribe as ethical code for a contractor or lobbyist? Is that possible?
Let me make sure I understand the question. Are you saying that if a governmental entity were to contract with the county, that governmental entity would sign off agreeing to comply with the county's ethical requirements? Is that the gist of the question?
This whole ethical is for employees, elected officials, board members, appointed people. The only thing that applies to contractors as far as that is this registration requirement.
So the contractors actually are subject to a number of restrictions, prohibitions on making of gifts or other types of influence. So they are subject to certain, restrict prohibitions, but those are more passive. It's more of a, you shall not do this. Whereas registration and training are more proactive. It's saying, if you want to do business with the county, these are things you have to do beforehand. And so that's really where some of these issues come up, is that I know the Inspector General's here. I know that we have a number of contractors, their registrations expire, we have to renew. There's some administrative costs surrounding that. And there are some efficiency matters where if it really is a smaller contract and it's hard to get somebody to sign a sheet of paper saying they did the ethics training, they may not have the means or the interest really in paying $100 for a $4,000 contract. That's just not in there. They're not getting a whole lot out of it, and it's burdensome in some manner. So the concept would be that all of the restrictions still apply to anybody who contracts with the county, but that the proactive things that contractors have to do would only apply once you reach a certain threshold, and $10,000 was that threshold.
Take for example the idea of discrimination. Is there anything in our code that requires a contractor or lobbyist to not practice discrimination in whatever they're doing for the county?
Yes, the contractors, and I believe also lobbyists, though it's a little more nebulous in that sense, because as a lobbyist, what would you consider a discriminatory act? I'm sure there are scenarios, but it's a little less concrete in the way that a contractor could discriminate. But our code says that contractors are prohibited from discriminating on the basis of all those protected classes that were listed earlier. So those restrictions still apply, whether or not you are required to register and undergo training.
Okay.
So the next section is actually on page 45. This deals with enforcement authorities. I apologize, the formatting got a little messed up here. It's the headline is on the bottom of page 44. And this just sort of spells out who's responsible for enforcing different parts of this code. And it's really broken down into, at this point, the Inspector General, the Personnel Review Commission, and the Department of Human Resources. It also used to include the Law Department, but the Law Department only had one responsibility, and that's now been transferred over to the Inspector General. There are a couple changes here, and you can see in the summary of changes that, you know, if there's now a contingency if the Inspector General has a conflict of interest in a particular matter, it directs the Director of Law to appoint an independent person or entity as sort of a special investigator to perform the function of the Inspector General until either the matter is closed or the conflict is resolved, one way or another. And it also updates the code to include the IG's enforcement authority relating to debarment. It requires the IG to provide individuals under investigation, as we said, an opportunity to rebut a presumption of influence related to accepting a gift prior to taking final action, and retains the same duties and responsibilities for the Personnel Review Commission as the current code, but which are now being transferred over to the Department of Human Resources, which, as a practical matter, have been performed by the Department of Human Resources. And then the Department of Human Resources is, you know, again, explicitly charged with training employees and investigating claims of discrimination and other violations that are more appropriately considered to be HR matters in certain instances. So that is the totality of the, at the very end, on page 53, this is just sort of a catch-all. There are a number of miscellaneous provisions in the existing code that were either not replicated in the new code or didn't fit well into one of the other categories. Really dealing with the minimum standards, severability, applicability, liberal construction. These are matters of construction of our code. I think they were necessary at the time the original ordinance was passed, given that the county was brand new, and the ordinance was intended to stand alone. Most of these provisions have been incorporated in other sections of the county code and apply to the code as a whole. So it seemed unnecessary to restate them here in the Code of Ethics. And then there is a new provision in the updated code that simply clarifies what constitutes proper notice for the purposes of noticing a debarred contractor, and they're meant to mirror the federal notice requirements. It's again to help clarify when contractors have formally been noticed of their debarment.
Thank you very much for that comprehensive presentation. I think we now have a very good understanding of what this legislation includes and what it does not include. Any further comments at this point? I have two amendments that I would like to present, and you have them on the sheet in front of you, and I'm going to present each of the amendments, and after I present them, if I seem to get support and agreement, I'll make a motion, and if there's pushback or want for more consideration, well, then I'll take it just as an initial putting it out there, and we'll consider it again possibly at a later time. The first amendment is on page 4, the top of page 4, and it refers to the definition of a lobbyist, and the current language excludes from the definition of a lobbyist any individual who spends less than 10% of their compensated time lobbying. The staff persuaded me that there needs to be some standard, but I believe this standard remains too broad in that you could come down and lobby every day to your heart's content for a whole month with anybody and everybody, and still be less than 10% on an annual basis. And so I think it's too broad, and the proposed amendment simply changes the 10% to 5%, and it's designed to ensure that people who are actually doing a somewhat significant amount of lobbying do register as such. So that's the amendment. I would invite if anyone has any comment.
No comment. Motion to amend.
Okay. There was a motion to amend, and I will second. So any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed say no. The amendment is incorporated. And the second amendment is on the bottom of page 7, and it has to do with the provisions that says that no one shall be required to recuse themselves under certain circumstances, and in the current language, number 1 is adoption of the county's biennial budget. Number 2 is a matter that does not involve the exercise of discretion, and 3 is matters involving discretion that directly affects any of the following groups or a lawful class of such groups. And I have 2 concerns. The first is that regarding the adoption of the county's biennial budget, I essentially agree with that, but believe it should be clarified that it refers to adopting the biennial budget as a whole. I think there could be individual amendments to a biennial budget that are specific and could particularly benefit somebody where recusal would be appropriate. But when you get to adopting the whole biennial budget, it's so broad and has so many provisions affecting so many people that it wouldn't seem that recusal would be required. So I just added 3 words in this amendment to read adoption of the county's biennial budget as a whole. The second part is that I proposed to delete part 3, the part about any matter involving the exercise of discretion that directly affects any of the following groups. And my concern about that section is that I think there could be legislation that, yes, it does affect everybody in a particular group, but that it affects some individual or some company or somebody in a particular or more substantial way where a person might have a relationship and a recusal would be appropriate. You know, so I think that rather than granting a blanket exemption in this case, that it would be better not to have this provision and to have a person use their own good judgment with the advice of the Inspector General if necessary when a recusal is required. So that's what the amendment does. It adds the 3 words to part 1 and deletes part 3.
Motion to amend.
I'll second. Any further discussion? All those in favor say aye. Aye. Any opposed say no. And that amendment is incorporated into the legislation. So we now have the substitute before us, and what we're going to do, the substitute involved a lot of changes. It's quite substantial. There's still some things we need to look into. There's section 403.04. I'm still not entirely sure about excluding the sexual harassment provision. There's some stuff about secondary employment we might still want to look at. And I just want to give everybody a chance to take a good amount of time, go through it in detail, and if you have any further suggestions or comments, to bring it forward. And we're going to have a considerable amount of time to do that, because the next time we would ordinarily meet is March 15th, when an event of national importance is taking place, the Ohio primary. So we're not going to meet on that day, and we're going to meet on March 29th, 4 weeks from today. So that gives plenty of time for everybody to go through it, to ponder it, to think about it, to make suggestions, and so we will continue at that point. But I do think that we have a very good piece of legislation, and that we're pretty close to the end. And on that note, I would ask the clerk if my name could be added as a co-sponsor of the legislation. And I would also like to commend the sponsor, Councilman Greenspan. This was a lot of work, and I know that many months were spent on it before it even got to the introduction stage. And although we made a significant number of mostly pretty technical changes in the substitute, I think 90% of the original concept is still intact in terms of the legislation as introduced. So it's good work.
Well, thank you. I want to give credit to Mr. King and the rest of staff, as well as Sister Joanne Gross, who started this process 3 years ago.
Mr. Chair,
Yes.
this has just had one reading, correct?
It's had the first reading in council, and it has now had 2 hearings in committee. So I presume that after we're done with it in committee, that we will refer it to council for second reading.
What I had in mind is that there's 5 members of this committee, but there's 11 council people. I'm just wondering if there's any benefit to sending this to council and then have it come back to committee, so that they would see what's been substituted.
Well, I personally don't like that process. So I would like, but I think the concept is a good one. So what I would like to do is to voluntarily bring the substitute to everybody on council's attention, both through the council meeting and otherwise, and encourage them to review them. But I do like to bring legislation to council for second reading when it's in its final form. The purpose of a second reading followed by a third reading is to give everybody one last chance in its final form to think about it before the final vote takes place, and on a piece of legislation that A, is complex and B, is important, and C, is not urgent. I think that's a very good thing to do. So that would be my preference, if that's okay. Okay.
Read it, Chair.
Okay. Thank you very much. And Has anybody signed in for miscellaneous business? Or for other public comment?
No, Mr. Chair, no one has signed in.
Okay. And is there any miscellaneous business from my colleagues? Okay. Move to adjourn?
Second.
All those in favor say aye. Aye. We are adjourned. Thank you very much.